Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. The Florida Bar thoughtfully provides all kinds of rules to guide lawyers in drafting pleadings. They guide them in the technical aspects of it, what the margins are supposed to be, how many pages, how many words, that sort of thing. And they also, in most ways, give you some indication of what you need in a pleading in order to get relief. Unfortunately, the rules don't always make it clear when you should file a motion, and they also don't make it clear that it really isn't a good idea to file a motion to get relief that you know you're not going to get just so you're going to get camera time on court TV. Now, I don't know that that's exactly why the motion was filed, but here are a few things to consider. And these are things that I withheld from my last video on this subject, just because I wanted to see how things played out on Monday, because it was really an interesting sort of motion hearing. Here are the issues. The first is they did not provide any support for their motion. As lawyers are fond to say, motions are not self-proving. If you put a claim or what is asserted to be a fact into a motion, it is a mere allegation until you provide some proof of it. And you provide some proof of it by attaching something like an affidavit or a document or a video or a recording, something of that nature. Now, when you're in the jail, you can't make a recording, but what you can do is you can swear out an affidavit, and that's what lawyers are for. Lawyers go into the jail, they swear you in, and they bring their notary equipment with them. They swear you, and you file an affidavit. And the affidavit generally says something about what you're seeking relief on. For example, if you are going to file a motion for injunctive relief and there is a document that is critical to your argument and you want the court to consider it, what you have to do is you have to attach it by affidavit. And the way you do that is usually the lawyer comes in and says, my name is John Doe, I represent Jack Doe over here, and this document was received by me from the state on such and such a date. It purports to be an email between Party A and Party B dated January 15th, 2023. And in whatever the subject of that particular communication is, you put that in there. And then you add at the end of that paragraph, this is a true and unaltered copy. The highlighting on the document is that of the affiant, so that you can clarify what's, in basically part of the document itself and what you may have added to it. And it's okay to add something to it, like highlighting, as long as you're not attempting to change the original meaning of the document. So when they filed this motion, they did not attach an affidavit from Donna Adelson. And that's really the only way that her allegations could be put into the record. Now, when they get to the motion, the first thing that the lawyer should do, if they really want injunctive relief, is to swear Donna in and have her testify. Normally, you swear in your witness and you take her through a direct examination. What happened to you in the jail? Well, they threw me into this room. They won't let me have a real bed. I have to sleep on the floor. All of that. And then you get that into the record. And then the other side gets an opportunity to cross-examine you. And in this particular case, the jail was and the sheriff was represented by counsel, and I'm sure he would have done a lovely job of cross-examining her, but because they did not want Donna cross-examined, I suppose, they didn't put her in as a witness. So the only witness was the person from the jail, and he did an absolutely perfect imitation of Sergeant Schultz from Hogan's Heroes. Now, some of my younger viewers may not understand that reference, but look up Sergeant Schultz on YouTube. You'll understand what I mean. He was the character who was famous for saying, "I know nothing," and usually he did know nothing. To make a long story short, in order to get injunctive relief, you have to show a few things. You have to show irreparable harm. In other words, this situation is so bad that unless I get this injunction, the world is going to end, dogs and cats living together, fire and rain, all that stuff. You have to show some kind of irreparable harm. Then you also have to show a clear legal right to the remedy. Now, the only thing that I think they had a real claim with regard to a clear legal right is the fact that they were not allowing contact with counsel. And that may have been a function of the fact that this is a Miami lawyer. She may not know how things are done in Leon County, Florida, and she had a lot of trouble getting an opportunity to speak with her client. And she said, look, the only time I got to see her was this morning when we talked about what happened in the jail. And the only reason I know about what happened in the jail is because Charlie Adelson's lawyer talked with her when he was in there. So it wasn't like she couldn't talk to any counsel. It was the fact that her counsel couldn't get in there and speak with her. Now, she does have a clear legal right to participate in her defense. There's no question about that. That is a right guaranteed her under the Sixth Amendment. The question is whether or not there is an adequate remedy at law. And generally speaking, if there is an adequate remedy at law, you can't get an injunction. One of the features of an adequate remedy of law is exhaustion of administrative remedies. So, they have a grievance procedure in the jail. When one of the people in jail, whether they're a pretrial detainee or a post-trial detainee, no matter what their status, if they are aggrieved by something the jail or its personnel have done, spitting in their food or slapping them upside the head, something like that, they have a right to file a grievance. And if Donna's conditions of detention are so bad, she could very easily, with the help of counsel, file a grievance and potentially get that changed. Now, I also think that she has a clear legal right to a psychological workup. The judge wasn't ready to do that just yet because, again, they had not shown that they had asked for that and that it was appropriate. I think they can probably at some point make that claim, but the bottom line was they wanted to get Donna into better living conditions so that she could be in a better mental state to help them prepare the defense. Now that's legitimate, but in order to do that, you have to exhaust your administrative remedies first, and the lawyer should know that, and they didn't do that. And then finally, the relief has to be in the public interest. You remember one of the things that they asked for in terms of relief was letting her go home on home confinement. And that clearly is not in the public interest to allow a murderer out, or an alleged murderer, out on bail or out on home confinement, even with a GPS monitor, because those things are not foolproof. And of course, the reason things aren't foolproof is because fools are so darned ingenious. But all of the relief has to be backed up with testimony. And she came in and she made, I thought, a reasonable argument. I don't think she hit the ball out of the park. I think at most she got a bunt single out of the fact that she wasn't getting a chance to see Donna as much as she would like, and that there was no way for her to examine documents and that sort of thing from inside the jail. Now, the sheriff did say, well, normally we give them a tablet, but because the tablet has a set of headphones that can be used to strangle somebody with, so we don't let them have the headphones when they're on this direct observation. In which case, the question is, if they're on direct observation and they decide to strangle themselves, what's the purpose of direct observation if it's not supposed to stop that? That was the proper argument to make in that particular remedy argument, but they didn't make it. And because they didn't offer any proof, any substantive proof, because the argument was not well thought out and it was not well briefed, and it was not well pled because they didn't get these facts in front of the judge prior to the hearing, the relief was denied, which is exactly what I would have expected the judge to do in this particular case. So, in this particular matter, it looked to me like what this was really about was public relations. They face a huge problem here because a large part of the Tallahassee community, and in fact, a large part of my subscriber base, absolutely hates Donna Adelson. Now, I think hating somebody is like taking poison and expecting the other person to die. So I certainly don't hate the woman, but if indeed she is proved to be guilty, what she did is, beyond the pale. She shouldn't have done it, and it was wrong, and it was morally wrong, and she ought to be punished. But I don't spend any time, feeling badly toward the woman because I don't even know her. Here's the key issue for me. You shouldn't file a pleading just to get public relations credit. What the game here is, oh, look, she isn't convicted, but look how badly they're treating her in the jail. And again, even the allegations that are in the pleadings don't have any weight because they're not sworn. And I would think that was an oversight if this was not an experienced lawyer. She's done a lot, apparently, of healthcare fraud defense, and so she understands how to get evidence admitted into a court. The failure to do the things that were necessary, both in the pleading and in the submission of proof, leads me to conclude that this was a giant PR move, that they really had no expectation of getting any relief, that this was all about humanizing Donna Adelson and making her look like a victim. Now, you can have your own opinion about whether or not you think that was an effective strategy. Personally, I don't. I don't think you advance the ball any by making people think that you're whining about the conditions of detention when, realistically, you put yourself in that situation. So we'll see what happens in the future with any additional motions, but for right now, it's pretty clear that the judge made the correct ruling in denying the injunctive relief. I didn't put any of the video in here. I downloaded it yesterday. The audio I did not think was very good. I just feel like probably better to explain how injunctive relief is supposed to work and what you would need to show to get injunctive relief, and then point out that they made really no credible attempt to do any of that. So if you have any questions, feel free to leave them in the comments down below. And of course, you can always email me. Of course, I would appreciate it if you would share this with other people. Let them know that this probably was a PR fail. And again, if you have the opportunity today, do something nice for someone. I'm always talking about doing nice things for people, being kind. One of the things I don't emphasize enough is that when you are kind to others, it always finds a way to come back to you. Now, yesterday I had to go down to see my retina specialist. As a diabetic, I have to have frequent retinal exams, and I had to drive all the way to Mobile and all the way back. It's like it wastes an entire day, which is why I didn't get this video made yesterday. But one of the things that I did while I was down in Mobile is I bought a particular gift for my wife for Christmas. On the way back, as I was doing some additional listening, I realized I'd purchased the wrong thing. So I had to stop at the Costco in Montgomery, Alabama, in order to get the thing that I really wanted to get for her. So I stopped in there, and there was a long line at the registers that are self-checkout. And I told the guy in front of me, I said, well, geez, at least there's a nice long line. I guess that means we get a chance to visit. And we had a nice conversation for a little bit. And then when a register opened up, it was his turn. He said, look, you only have one thing. Just go on. And so I told him thank you, and I went ahead and did that, and I got out, and I actually got home in time to have dinner with the family at the Mexican restaurant, which is sort of our Tuesday thing. But that illustrates to me the real joy that comes from doing nice things for other people. People are much more likely to do nice things for you if you have that aura of somebody who is respectful and who tries very hard to be a good finder. Somebody who finds the good in even a bad situation like having a long line, because it gives you the opportunity to talk and share and perhaps distract someone from their own troubles. So I wanted to point that out. I thought it was important. If you have the opportunity today, please do something really great for someone, whether it's buy them a good Christmas gift or whether it's, throw a couple extra dollars in the cleaning lady's bucket because, you know, she does a good service for you. Do something nice for someone. I can assure you, it will come back to you. Perhaps not that day, perhaps not that hour, but it'll come back. Have a great day. Thanks for watching, and come see me tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.